Your Honors, may it please the court. There's a overarching kind of idea that cases should be determined on the merits and not on technicalities. And I think this case presents a quintessential instance of where a case was determined based on technicalities. In fact, it was based on a technical error due to e-filing.
But counsel, you say technicality, your opponent says affirmative defense.
Right. Well, I guess the affirmative defense arises from the technicality. As your honors know, when the complaint was timely filed, there was a problem in e-filing resulting from the fact that two of the numbers in the bankruptcy case number were transposed. And as a result of that, the adversary proceeding was associated with the wrong bankruptcy case. Due to that, let's go back a little. The complaint was timely filed on July 9th, 2021, and under Rule 4M, the trustee had until October 9th, 2021 to serve the complaint. Because the complaint was associated with the wrong case, there's a docket entry in the misfiled adversary that directed the trustee as the plaintiff to, quote, withdraw the complaint and refile it. The problem is that there is no means of withdrawing a complaint from an adversary that's been associated with the wrong case. Before the dismissal of the misfiled complaint, the trustee refiled a complaint and associated it with the proper bankruptcy case. And on October 7th, 2021, which is before the deadline to serve the misassociated complaint.
Are you arguing that the deadline to serve the summons to the complaint somehow is tied to the timeliness?
No, Your Honor. My point there is that that the refiled complaint was served within the same amount of time, or within the time period that the originally misassociated complaint could have been served, so that there is a basis to apply equitable tolling, because it's not as if the defendant received a copy of the complaint after the time that it could have received the misassociated complaint, so that there's no prejudice.
After the filing, I mean, after the limitations period expired.
Well, it was served with it, but there's no rule against serving a complaint after the statute of limitations period has expired.
No, I just perhaps I misheard you. I didn't understand. So your equitable tolling argument that you're advancing is: look, we filed a complaint timely within hours of the deadline imposing, but it was timely running. We filed it timely, and after all this kerfuffle, we ended up serving something on them that was within the time if that would have been appropriate if we had filed it in the right place. Is that correct?
That's correct, Your Honor. And the notion that equitable tolling is usually applied in situations where the claimant is actively pursued his judicial remedies by filing a defective pleading during the statutory period, and then there's some kind of extraordinary circumstances that stood in the way of pursuing those claims in the appropriate manner. And here that problem was that somebody transposing two numbers when they were e-filing a complaint that resulted in, as Your Honor mentioned, the kerfuffle.
Yeah, that's a technical legal term.
Right. So I guess the idea here is going back to the start, is that this is a case that was determined. I know that the ultimate rule that was utilized for dismissal of the complaint was Rule 12, but that ruling was based on a technicality that we had transposed keys numbers resulting in a complaint being misassociated into the wrong bankruptcy case, and instruction to withdraw the complaint, which is not any kind of option that's available under the e-filing system.
Well, let me stop you
Sure.
at that point, okay? I think you're careful eventually in your pleading not to suggest that you were either soliciting or accepting legal advice from the clerk's office, correct?
Correct.
Okay, if you can't do that, why are you, quote, taking instruction, close quote? I mean, most of your brief seems to be going along with, well, we just took instruction. There certainly were other things you could have done. I mean, you could have had a 105 status conference at any time to ask the court, is there a better way to do this? So you didn't do that, did you?
No, Your Honor, but to your point about the legal advice issue, I think there's no dispute that there is an entry in the misassociated adversary where there's a direction from I don't know if it's from the clerk or the clerk, but it does appear on the official court docket to withdraw and refile the complaint.
No, I thoroughly understand that.
Yeah.
The question is why. I mean, if you're not asking for or taking legal advice, why are you, quote, being instructed? I mean, weren't there other things you could do?
I guess that there are other things that could have been done, but that I don't know. There is an instruction on the docket. I don't know if it's, I wouldn't call it legal advice, but if I see something on the docket telling me to do something, I do it because I assume that that's what the court wants me to do.
Well, look, I mean, I'm going to ask a more pointed question. If the, or maybe I'm not, but I'm kind of astounded by that argument because, number one, everyone knows it's the clerk, not the judge, as in the court. Because when I instruct you to do something, when any judge instructs you to do something, there is an order signed by the judge. You don't have that, do you?
No, Your Honor, I do not.
And so it's not contempt if you take a thoughtful approach to it and weigh your client's rights, correct?
Correct.
And so, it's to say, you've stopped just short, and I mean just barely short of saying I didn't have any option, but you had an option, didn't you, to not do it in the way you did it? Or when I say you, right. I mean...
Yeah, I understand, Your Honor. I mean, of course, there's always or almost always more than one way to go about something. I mean, in this instance, as you know, we filed the new complaint and associated in the right case before we took any action in the misassociated case. And then, I understand the distinction between legal advice and a direction, but, even in addition to the entry on the docket to withdraw the complaint, then there was a call to an assistant at our firm and to myself, a voicemail telling us to dismiss the complaint. But I think, whether it was dismissal or withdrawal, that you end up with the same technical issue on the docket, that if we would have, quote unquote, withdrawn the misassociated complaint, we would have had no action pending, and then a new complaint filed, same as the one that was dismissed and the misassociated action filed, and somebody just transposed the number of the bankruptcy case back to where it should be, and it was filed and then timely served on the defendant, to where just like we had a number of things that we could have done to proceed. I think the court also had some ways it could have proceeded in terms of applying equitable tolling or directing the clerk to associate or to consider the refiled complaint a continuation of the prior action, anything to avoid having a case determined on the technicalities. So with that, I'll reserve my time. I don't know exactly where I am on the clock, and hopefully can answer questions on the rebuttal.
All right, you've got about 6 minutes left, so we'll stop here, and you may reserve the rest of your time. All right, Mr. Calzada.
Good morning, members of the panel. I'm Glenn Calzada. I'm counsel for the appellee and defendant Hai-Ho Yang. May it please the court. When this case came to me, the main concern I had with the plaintiff's trustee's position was that it appeared to me that they were trying to tie Mr. Yang to the filing date of a complaint he was never served with. And in his mind, in our mind, that case, that complaint, that filing date means nothing to him.
Why? Why? Is that an element for relation back?
Yes, because the relation back issues with respect to Rule 15 talk about an original complaint.
There was an original complaint. It was just in the wrong case.
Exactly. And in fact, there's some cases that we cite, O'Donnell that talk about that a refiled complaint is
Well,
not.
after it's dismissed. But in this case, the second complaint was actually filed while that original complaint existed.
And he didn't learn about the existence of that original complaint until the time for service under Rule 4M that also talks about a complaint.
What is the significance of that? What would have
Had
happened?
expired. That time had already expired. So
What would have happened, though? You would have moved for failure to serve within the 180 days?
I did move to dismiss. I did move twice to dismiss the complaint. And Judge Zerzolo did see that the failure to serve and to take that long a time period was a lack of diligence. And he did exercise his discretion.
But that's as to the equitable tolling.
It did, but he also did distinguish the O'Donnell case, because in the O'Donnell case, he did mention that the employer was served with the complaint in that case, which was not the case here. And that was the basis for why he did distinguish this situation from what was happening in O'Donnell. There is just, to me, when I look at their case, and he filed 24 complaints on July the 9th. And, when you do that, you just take your chances, okay? And I took a look at the case, and you can see the banner. And the banner, that's a docket number, excerpt number, page 314, shows that this case was filed at 3:49 in the afternoon. The 24 cases that are all on the docket there, they started filing cases at 1:30 in the afternoon, and they ended up finishing at 11:45. And I know, and Judge Zerzolo knows, and the clerk knows, that every time a case is filed, it shows up in the case docket. Well, at some point in time, you get a clue that this is misfiled. So they not only had on day one, the day that they're filing the cases, and they're doing this to themselves on, for whatever reason, and then they get notice that same day. They get notice by way of the docket. They get notice by way of the summons. And the summons say the Garcias twice on dates. They could have easily sent over notice that the existence of the case had been filed. They chose not to do so. They didn't give us notice to the status conference. They could have brought this up in a JSR had they been, like you said, alternatives. There were alternatives. And they could have brought this up by way of simply just a motion, some sort of request for the judge to reassociate this case with the proper filing. What they did here is they served and refiled the same equally defective case. And they know it's defective because as soon as I filed the motion to dismiss the second filing, which was completely devoid of any way you can tell. They said 5 or 6 years ago, you got transfers in the aggregate amount of almost $400,000. We're not going to tell you the date. We're not going to tell you the amount. But 5 or 6 years ago, you got that. That was the complaint in both times that they did that. We didn't learn about the actual transfers. You didn't have a meaningful Rule 8 case until November 12th. That was an actual case. So if there is something to relate back to, you got to have something that's actually viable, that's actually worth its while and could withstand a motion to dismiss. They didn't go there. They served that in November. So what were we served with? We were served with a piece of paper that said, you owe $400,000 to the trustee for something that happened 5 to 6 years ago. And yes, Judge Lafferty, this is not technical. They're saying, we substantially the same. What we had when we served you on October the 5th was a case that was the same as the one we filed on July the 9th. The main differences are the filing date and the case number. But the filing date is dispositive. That's the affirmative defense. that they were then deprived of. And they said, no, I want to relate this back to a case that you were never served with, because we gave it our best shot on that day. Did we? And then Judge Zola was looking at this and says, you had a lot of different options you could have done. And you didn't come to me. I don't see it. I don't see the diligence here. So it's not only equitable tolling, but there is no way that this is a Rule 15 case, a Rule 4 case. It's completely within his discretion to decide whether or not to dismiss it, and he dismissed it. And he is in the best position to determine whether or not it's in the interest of justice, to dismiss it. There's no reason to second guess him, but they're only here today because he exercised his discretion in that fashion. They want you to just ignore the rule. Hey, you know what? We want to decide it on the merits. But if there's any questions, but that's really the point I'm trying to make.
Anything further? Any questions? Judge Spraker?
No, thank
Judge Lafferty?
Thank you, no.
All right. All right. Thank you very much. And we'll go back to the appellant, Mr. Arnold. Again, you've got about 6 minutes to respond.
Thank you, Your Honors. I think there at the end, Mr. Calzado is kind of blending the issue that we have here on this appeal, whether there was an appropriate dismissal based on statute of limitations grounds, and whether there could have been some proper dismissal based on 12b6 failure to state a claim, which is not the issue here. There are issues raised about, the misassociated complaint wasn't served on us, and I'm not sure why they'd want that complaint served on them. But I think the important point in that regard is that the properly filed complaint was served on the defendant, still within the 90-day period under Rule 4M applicable to the misassociated complaint. So because of that, there wasn't any kind of prejudice to the defendant. I think the spirit behind Rule 4M is you don't want to have a long gap in time before a defendant gets notice of claims against him or her or it, because you don't want to have some kind of loss of evidence, memory, or witnesses that could help the defense. Again, I'll just reiterate the point. Maybe there's questions, because I think it is vitally important here that the case was dismissed based on the most technicality you can have, somebody transposing case numbers when filing an adversary complaint, and that this action should be determined on the merits. So with that, I won't reiterate the arguments, and if there's any questions, I'm happy to answer them.
I'm just going to ask, is it really fair to say, I agree that the transposition is the kind of technicality that you state, but is that really the only basis? I mean, that's like the first problem, but isn't there also a problem with what followed from that?
Yes, Your Honor, I agree.
Also a basis for decision.
Sorry.
I mean, I think it's let me rephrase. Isn't it unfair to say that the judge decided this solely based on the transposition of the numbers?
It is and it isn't, and I'm sorry to waffle on that, but you're right. I mean, the genesis of this appeal and this issue and the dismissal was the transposition of the numbers. I guess there are a myriad of things that could have happened after that, both in terms of what we could have done. We tried to do our best to, one, file the complaint and associate it to the right case before dismissing the other one, to follow as good as we could the direction we saw on the docket to withdraw the complaint, and to timely serve the properly filed complaint on the defendant. So that's why I kind of waffle on the answer.
Okay. All right. Any further questions from my colleagues? Okay. All right. Well,
Not for me. Thank you.
Thank you, Your Honors.
All right. We will take this under submission. Thank you for your good arguments.
Thank you.
Thank you.